Hey guys, finally got back over here. I was trying to take a few minutes, let a couple people get up on here, and you know, uh, I'm waiting for you trolls and you traders and you bootlickers and haters. Now's your time to get on here and let's have a chat. I know for a fact that I ran a couple off because you couldn't stand the fact that the Dark Angel provided you too much proof and you couldn't dispute the proof. So that kind of screwed with you a little bit. And that right there for me is a beautiful thing because I love the fact that when I can sit there and provide proof 100 that you can't dispute, and all you can do is just provide your words with nothing to uh, support and or back it up. That makes me feel good to know that's how that goes. So, you know, I just want to let you guys know that, yeah, I love my haters. So, yeah, I love my haters. I love all y'all. All y'all that hate me, I love you. Because of the simple fact is, you can't disprove anything that the Dark Angel's saying. See, this has been an ongoing dispute for so long that you people have been so brainwashed to believing that the system is designed to be the way that you think it is. But it's not. It's not. So, surprise to you, surprise to that. Haha. And I'm glad that it broke your hearts. But, on the same strength, I hope really deeply down inside that it taught y'all something. You know, Granted, a lot of y'all get on there and you believe that a lot of the stuff that's being said is just a bunch of mumble jumble. And, you think that what you have to say is correct and what everybody else has to say is incorrect. And one thing I have learned over the course of time dealing with all the haters and constitutional traders and all is they all believe that you are supposed to that you're supposed to just bow down and be the one to say, hey, you're obligated to do this or you're obligated to do that. And what the reality of life is, the reality of life is we we have all, even us who are educating the masses, have been duped into believing that the need for a driver's license, you know, uh, is associated to everybody. We all believe that, you know, and we all fell into that. We all got duped into believing that, a driver's license was issued to everyone. However, just history alone, reveals and shows that over the course of time, if you look at all the case laws that's been generated from the past, you will note that every single case law refers to refers to commercial commerce, you know. And then you have some people who actually they tried to actually dispute that and say, well, there's case law out there that establishes that all motor vehicles are required to have a license. Well, no, that's where you're wrong because that is not referencing personal private automobiles. That's referencing automobiles that travel in that of commerce. Taxi cabs, Ubers, Lyft, Uber Eats. That's what they're referring to when they're telling you that all automobiles are subjected to licensing and registration. They're not referring to personal private automobiles. At no given time, and never has it ever been established a case law that actually addressed a personal private automobile. There's a couple of case laws that were established about the taxing of personal private automobiles, as well as what it was in reference to was double taxing. So basically, what the state was trying to do, or that particular state was trying to do, and I believe that was up in like Illinois, Michigan, somewhere up in there, in that area, the state was trying to force a tax on a man who had several automobiles that was his own personal automobiles, and the fact that he tried to use them in, well, he actually wasn't trying to use them in commerce, but they tried to claim that he was using them in commerce, but he actually was not. So, and anyway, he the state was not allowed to charge him in reference to that. So there's that, and the double tax come from the business as well as the automobile being utilized in that of his own personal conveyance. But you know, on the same strength, he beat the case based on the fact that one, he was not utilizing his car for business. Now, every case law that ever been established is basically a license that you know was issued by the state for doing business, and this is any state, every state, all 50 states. So basically, what everybody has not understood or misunderstood is the fact that every license that's issued through the DOL, the DMV, the DOT, whatever your state calls your Department of Motor Transportation, your licensing department. Ours here is the DOL. So Department of Licensing. So I've covered this in past videos where I've told you guys that the Department of Licensing only issues one license. It's a fact. It is a fact. It cannot be disputed. It is a known fact. So you can sit there and say, well, they have non-commercial driver's license. They have these, they have this. No, they don't. No, they don't. And for you guys who believe that, shame on you, because you need to establish your facts before you go running off at the mouth, you know? Uh, hey, Sarah. Yes, I got your message. How you doing, honey? See you loud and clear. And I hope you hear me. I'm not typing right now, but if you hear me, just acknowledge it. Yeah. So, the DOL, they uh, they only issue one license. They've always have. What it is a lot of people misunderstood what the classifications are. Class A, Class B, Class C. Now, you got to understand and know and discern the difference between a Class A, Class B, Class C. All these is classifications of authority. That's all they are to one license. You get a standard driver's license. If you look on that license, it's going to have the word CDLEND on it. Okay. And it may be on the front, it may be on the back. I'm not sure. Here in Washington, they're on the front. And they actually say CDL and END. CDL is on the back, the END is on the front. END stands for endorsements. Okay. Your classifications A, B, and C, all that is just authoritative. They're authorities that give that license the authority to operate that motor vehicle in a certain capacity. Weights, double trailers, passenger vehicles, food, uh, things of that magnitude. That's basically what those classifications authorize that license to do. You can check on that, and everything I'm telling you is facts. There's no bullshit in this. Okay, you you need to do your own research and realize that when you come into a situation like this and people are feeding you information like this, you really want to know the facts, because it's always best to be thought of as a dummy than to be open up your mouth and be known as a dummy. Especially when you have nothing to support anything that comes out of your mouth. That is not that's not how it works. Like I said, I'd rather be thought up as a dummy and have people believe that that's what I am, and then when I open up my mouth and they say, "Oh, dang, this man, he's far from a dummy," you know. So yeah, but anyway, I got on here today because I wanted to get a couple of things out there. I wanted to get something out there that was. I covered this a while back, and I just wanted to. I didn't elaborate on it then when I covered it, so I want to elaborate on it now. So basically, the judicial system and the attorney general. The attorney general, in a brief, admits, as well as the court system. So they both admit and confirmed exactly what I've been telling y'all. So the judicial courts, what they've done is they've gone and confirmed that the Department of Licensing only issues one license, and it's for hire. That all licenses issued, license registration, anything is in fact for hire. So every single automobile out there that's ever been licensed and registered through the DMV, the DOL, is a registered business. Okay? Because one thing you have to keep in mind is the United States is a corporation. Okay? So, and if you don't understand that it is a corporation, then you need to know that you're living in a fantasy world. The United States is a corporation with corporations within. And I've explained this before too. And for some reason, I see a lot of you guys get on here and you make comments and things of this magnitude, and you seem to fail to understand that a license is for business. Okay. Every case law that's ever been established tells you that. You know, uh, I know that there was a dispute with a couple of people who disputed the case, the Dunkard case that I have read a while back. But when I broke that case down, then they realized, oh crap, he's right. Yeah, I was right, because my assessment is not my assessment or my opinion, it's the opinion of the court. You know, the man failed to apply for a business license, whereas he was using his business automobile as a personal automobile, and therefore they couldn't do anything about it, because even though the car was supposedly to be registered and licensed for a business, he was in fact using it as his own personal automobile. So therefore the court lacked jurisdiction in that matter, due to the fact that per the Constitution, okay, of the United States of America, the Article 1, Article 1, Chapter 10, Paragraph 4, I do believe, and I could be wrong on that. I do believe that's title of nobility. However, anyway, the bottom line is no state has a right to intervene in that of your own personal private affairs. Fourth Amendment, actually. Okay, so the Fourth Amendment actually confirms that you are allowed to travel anonymously. A license and a plate is not anonymous. And whatever part of that no one's ever getting or understanding, I never could figure that out. However, when you register your motor vehicle, your information goes in a national database. Okay, whether it's a statewide database or a national database, either or, your information goes into a database. Period. When that officer pulls you over and he runs your tag, that man knows or woman knows more about you walking up to your car than you know about him. But by law, you're allowed to travel anonymously. That's not anonymous if my information's out there. So, point blank and simple, the bottom line is what I'm getting at is this. The judicial system and an attorney general has confirmed a few things. So, I want to go ahead and get it to give you guys an insight as to what the judicial system says. Now, what I'm reading to you is straight from a manuscript, straight from the court. So, you can take this however you want. You could take it with a grain of salt, or you could take it to heart because it is the facts. So of special note here is that the legislative policy has the blessing of the judiciary. The judicial blessings are supportive that the legislative policy is and only commercial in nature. This leaves only the executive branch of government to be reined and bridled as to their enforcement of interpretative presumption. Noting, of course, the executive does not have authority to interpret statutes, neither can they presume the statute to mean anything more or less than its intent. Okay? Now this was a note from the courts, letting you know that they confirm it's the statutes are commercial. Always have been, always will be. But as I've told you guys, and I never showed you guys, but as I've showed you, so this right here, okay, you can see how thick that is. This was sent to me via an anonymous Supreme Court justice and several prosecutors. This manuscript that I've been making the videos on is based on their findings, their conclusions, their opinions, their law. They've included in this manuscript law they don't want people to know. Law that has been buried. Okay? Now, I will say this, like I said, I don't understand why the judge who sent me this sent it to me. He doesn't know me. I don't know him. I've never heard of him. You know what I'm saying? And I don't know any of the prosecutors and or lawyers and attorneys that were all involved in the making of this manuscript. But I will say this, you come back here to front of this, there is 3 pages of credits in here to all of the individuals who did the research on this particular manuscript. Okay. And you have one here. I'm actually going to give you a little insight. 1, 2, 3, 4, 5, 6, 7, 8, 9 attorney general opinions that's cited throughout this whole manuscript. You have over 60 different prosecution opinions and over 300 judges' opinions. Now, everything I'm telling you is law. It's 100% factual law. It's not law that's been superseded. Ever since I've been reading this manuscript, and I think we're on part 3, I believe, in my video sessions. We're on part 3. And you know what's so interesting is that since I've been putting those parts out there in this series. It's going to be a long series. I've actually put the manuscript down for a while because I've been actually doing other videos in reference to some of the things that's been mentioned in this manuscript. Okay, so my point is in doing this manuscript, reading this manuscript, it has brought me on point to a lot of things that the courts did not want the public to know. They've taken case law. I've published actually on some of my videos. I've actually published a few of the case laws that if you go online, you're not going to find them. Because if you don't know nothing about them, then how can you look them up? So what I had to do is archive them. And that's how I've actually located the actual cases, because that's how buried these cases were. They were all archived right away. They were decided, they went to trial, they were decided, ruled on, and buried, all in the same strand. There's a few that may have been published, but for the most part, none of them's been published because they don't want the public to know the truth about the matter about driving without a license or a registration. So the bottom line is this, ladies and gentlemen, a driver's license is commercial. The DOL, the DMV, the DOT, all these are commercial entities within the corporation. Period. You can call it whatever you want. You can sit there and argue until you're blue in the face talking about there's a standard driver's license, there's a commercial, non-commercial driver's license. No, that's what you've been duped to believe, that there is a non-commercial driver's license and a commercial driver's license. And you will hear that standard, like here in Washington, they call it, you can go to the DOL and apply for a standard driver's license. But again, like I said, proof, fact, and positive, when I researched that and looked at a standard driver's license, on its face, it says END, endorsements. Now, every state has to come in conformity with the Federal Motor Code. And the Federal Motor Code is commercial. Every state has to. So it's not that they can bypass it. It's not that they can overlook it, because they can't. They have to be in conformity with the Federal Motor Code. And I've showed you guys the FMCSA manuscript as to where, when the cases are talking about, well, they can regulate this due to safety. Yeah, they're privileged. They sure can. They can't mandate or regulate your right. They can't touch your rights. Your rights are inalienable. And under common law, they can't take them away. They never gave them to you, so therefore they can't take them away. Hence the reason, again, for no jurisdiction. Hence the reason, again, why there's no statute on it, because as I've told you from the very beginning, where no policy or statute exists, no law can be enforced. No jurisdiction exists, period. And the courts know this, and they're scared, because let me tell you something. When they started issuing a license, they found an untapped resource of revenue. They know they can get the money, charge you a fee for your license, But again, all licenses are issued in the business sense. So that first two paragraphs that I read to you, that was actually the notice coming straight from the judicial system. Okay, the court system. So now here's what the Attorney General had to say. The state of Washington wholly concurs with its writers' rendering of the statute, policy, and law. The following is former Attorney General John J. O'Connell's opinion as to the intent and application of the operator and driver's license. Now, if you keep in mind, pursuant to that of the Supreme Court, law of the land, a driver and an operator is one and the same. One who, what? Controls a motor vehicle for that commerce, gain, Imagine that. And that's what the Supreme Court says. They actually have the definitions and everything. You just need to go pull up Black's Law Dictionary, and you'll find out that that is exactly the truth. It's 100% the truth. So, you can't just dismiss the truth, and accept what you believe to be your truth, because ignorance of the law is no excuse. So you got to keep that in mind too, because that's exactly what they're going to tell you. Ignorance of the law is no excuse. So anyway, uh, as a former representative of the state of Washington, he agrees that all statutes relating to operating and driving are static, as well as confirming that this is Attorney General O'Connell. Now he says all licensing issued by that of the Department of Licensing, the DOL, are in fact issued to for hire. Statutes and whoops, hang on a minute. I got lost. Statutes and by use of the Latin legal maxima expressio unius este exclusio alterius means to have one thing that excludes all other things. So that actually applies to the statute. So I'll explain that here in a little bit as to what that means. So basically, what he acknowledged was no license may issue for personal use of an automobile. Whoops. This is Mr. O'Connell's opinion. No license may be issued for a personal automobile. All licenses issued in the state of Washington are in fact licensed for hire. All license, he says. Not some, not this particular group or this particular batch, all license. And that's Attorney General 6162, number 46. Okay. So basically, what he goes on to say is the business of operating as a motor carrier of freight for compensation along the highways of this state is a business affected with the public interest. The rapid increase of motor carrier freight traffic and the fact that under the existing law, many motor trucks are not effectively regulated have increased the dangers and hazards on public highways and make it imperative that more complete regulations should be employed to the end that the highways may be rendered safer for the use of the general public. Okay. Now, if you remember the case laws that's been read from the past, they were always telling you about how the state can use its police power to regulate, the way traffic moves on the freeway. Well, RCW 81.80.211 provides this. Now, this is the Attorney General that I'm reading from. This is his brief that he had on a case. So this is how he argues this case. The Commission may adopt the rules and regulations relating to the hours of duty of motor carrier drivers and operators. Okay, now, if you remember, for those of you who do follow me and you do know what I used to do, I used to be a commercial driver. So what he's talking about there is an electronic log device, an ELD. And what that log does, it regulates how many hours you can sit behind that wheel while operating that motor vehicle. Okay. Regulations. Now, ask yourself this. What law, statute, and or policy is in place that does that for automobiles? You decide to get in your automobile and travel from one end of the United States to the other end of the United States, unless you're zooped up on some really good shit, you'll probably make that drive in a matter of 3-4 days. I'm not advising that you do that, so don't go there. But anyone with common sense would know that if you go and start heading out and decide to travel from one end of the United States to the other end of the United States, that common sense would tell you to get plenty of rest. So you would periodically make stops to rest. you're going to periodically make stops anyway to use the bathroom, to eat, et cetera, unless you're one of those grab bag drivers that has, you know, a bunch of food and stuff sitting beside you and a pee bottle on the floor of the car or whatever, you know, and you just decide that you just want to go nonstop, you know, which is ridiculous in my opinion. But hey, you know, as a driver, as a past driver of a commercial motor vehicle, uh, I know that life. I know that life very well. You know, my wife can attest to that. She's been with me on my trucks. She's been with me cross country. We went from one side of the United States to the other, up and down, all around, back and forth. We've been everywhere, you know. And yes, I have slept in all 50 states. Yes, I have driven all 50 states. Yes, I have. I've been doing it for 25 years. And when I canceled that contract, my license actually was suspended. So I went on and canceled the contract, period. I terminated it. Because when I realized that in the private side of things, you know, the best thing to do in that factor is to sever all contracts. So I did. And I actually, uh, I don't remember exactly which video it is, but in one of the videos, I actually show you the CDL that I have. And I actually do have it. So, you know, I actually keep it right here as a momentum, as a memento as to what used to be. And that's why I still have it. So this CDL, and I don't know why this thing does not want to cooperate when it comes to showing this CDL, but there it is right there. So this CDL here is canceled. Contract, not valid. Okay. So, yeah, you know, I did away with that contract. Now I travel without a license. I don't even have a license. I don't own a license. I don't have plates on my vehicle. I've showed you guys my pictures of my personal automobile, and I have private plates on them. Yeah, you can order them anywhere online and what have you. And that's what I did for now. You know, I'm going to have my own personal plate eventually made. Uh, I just haven't decided what I want to put on it yet. But on the same strength, right now I have private plates on my personal automobile. And again, you know, a lot of things have been brought to light, me from people in the movement who are actually doing wonderful things, great things. But anyway, I want to get back into this because I want to get this read as to what this attorney general was telling you. Now, keep in mind the manuscript that I'm reading from. These are laws, rules that the state, the courts, and the police don't want you to know. They don't want you to know anything about this stuff because, again, by your canceling out your contracts with the state, you are affecting their untapped revenue source. Because you got to remember the state is a business. They did not get into business to lose money. They got into business to make a gain, make a profit. That's the whole point of it. And that was the reason why the commercial activity was issued in the United States, was the fact that it was an untapped resource that provided instant and constant revenue. The taxing, the cost, the commercial cost of utilizing the roads. You see what I'm saying? It's that's what it was designed for. It was designed to do that. So anyway, RCW 81.80 290 provides in part the commission may by general order or otherwise prescribe rules and regulations in conformity with the chapter to carry out purposes thereof applicable to any and all motor carriers. There you go. There's the regulations. And as you see, it says exactly what the law says. Safety regulations. A lot of the case law, they sit there and say, well, yeah, it's the laws in reference, they can regulate all license in reference to safety for the public. No, they can't. Don't know where you got that idea from. Bury that idea because that's not the truth. The fact of the matter is the safety regulations that they impose is on commercial motor vehicles. Where have you ever seen a safety regulation for an automobile? Yeah, didn't think about that one, didn't think it through, huh? But the bottom line is, okay, like for instance, so when I drove 18 wheeler, every 2 years I had to update a medical card. And what that medical card did was you had to go in for a physical every 2 years to get recertified medically to prove that you can actually operate that motor vehicle. Well, there you go, ladies and gentlemen. That's that part in that law where it's talking about the regulations for safety purposes for the public. There you go. You want to make sure that the individual that's operating that motor vehicle, that motor carrier, okay, still remains qualified, sharp, and to the point, and can still perform and conduct his abilities to control that motor vehicle. Now, when you get a standard driver's license, okay, you're only required to take the test one time. And for your lifetime, as long as you renew your license before it expires, you never again have to take a test. Right? Right. So let me ask you this question. Let's get this message out there real quick. If you only have to take a test one time, driving test one time, when you get a i.e. standard driver's license, and somehow the courts, the system has got you believing that you're acquiring a driver's license conforms to that of safety measures and safety concerns for the public. You have to ask yourself a couple questions, first of all. One, how does that license help the public? How does that license prevent accidents from happening? Human error. You get a license today, go out there and cause an accident tomorrow. Bottom line. That's simple. It can happen. Does that make you an unsafe driver? No, it don't make you an unsafe driver. It's called human error. It's what happened. It's an accident. Now, when you read the laws and you talk about the state's right to regulate, et cetera, they're not talking about personal private automobiles. They're talking about their business, their commercial, their commerce. And that includes automobiles that operate in commerce. Okay. So you have to keep that in mind. A lot of people think that it's personal private automobiles. No, courts don't have jurisdiction over personal private automobiles. They never have. Okay. So learn to discern the difference between them. Yes, you have private automobiles for hire, cabs, Ubers, Lyft, So outside the confines of Chapter 8180 RCW, but of prime importance and significance to our consideration of this matter is RCW 8104460, providing the Commission shall enforce the provisions of this title and all other acts affecting public service companies, the enforcement of which is not specifically vested in some other officer or tribunal. Oops. Thus, addressing ourselves solely to the portion of your question which relates to driver qualifications, we conclude that the Public Service Commission has the authority to both adopt and enforce rules and regulations governing driver qualifications with respect to auto transportation companies and motor freight carriers only. By this, we do not mean to imply that such authority includes the power to prescribe conditions precedent to the issuance of a motor vehicle operator's license. The general supervision and control of the issuance of vehicle operator license is specifically vested in the director of licenses. However, the commission may prescribe safety regulations over and above those prerequisite to the issuance of a driver's license with respect to the drivers of auto transportation companies and motor freight carriers only. Insofar as your question relates to the authority of the Commission to adopt and enforce rules and regulations governing safety of equipment, a final conclusion at this juncture would be premature without first considering certain provisions of Title 46 RCW. The provisions of this title relating to the certificate of ownership, certificate of license, registration, vehicle license plates, and vehicle operator license shall be exclusive. In this respect, it is worthy to note that although several provisions of the chapter and chapters, everything that I'm leaving out is just they're referencing the RCWs for Washington, okay, have been amended at various times since the original enactment of the amendment of the RCW 46. The legislator has never seen fit to amend it in any way particular to any of the provisions stated above, which grant the Public Service Commission the authority to regulate the safety of operations of auto transportation companies and motor freight carriers, respectively. Now, keep in mind what I'm reading here is from the Attorney General. Okay, this is what he says. Under these circumstances, we do not feel that it can be said that there is a manifest intent upon the part of the legislature to effect a repeal by implication. Under the maximum expressio unius est exclusio authoritas, it is the uniform rule that the express mention of one thing in a statute implies the exclusion of all others. Motor vehicles working in that of commercial commerce, excluding personal private automobiles. Excluding personal automobiles. Provisions relating to the same subject matter embodied in different statutes should be harmonized so as to maintain the integrity of both statutes whenever possible. Furthermore, as previously noted, the authority to regulate granted by RCW 46 and other provisions of that same chapter apply to motor vehicles generally. It is well established that a general statute does not repeal a special statute on the same subject unless the intent to repeal is manifest, and such an intent cannot be implied unless the two acts cannot stand together and an effect be given to both and causes cited therein. In determining whether any particular rule or regulation of the Public Service Commission is in conflict with those of the State Commission on Equipment or those set forth in Chapter 46, the test is whether the former permits or license that which the latter forbids or prohibits, and vice versa. There yet remains for consideration the question of the Public Service Commission's authority to enforce those rules and regulations which it properly adopts. Its authority in this respect is sufficiently prescribed in that portion of the RCW. The Commission shall enforce the provisions of this title and all other acts affecting public service companies and the enforcement of which is not specifically vested in the same other officer or tribunal. There you have it. And that's straight from the Attorney General's office. And he's telling you, no, personal private automobiles don't require a license. And he said it. This isn't in reference to personal private automobiles. The license is in reference to anyone doing business on the highways. And that he's Attorney General John Connell. Now, here's the thing. Here's the interesting thing about this is this Attorney General was the Attorney General here in Washington in 1968. Okay. Yeah. 1968. The case laws that these are referring to, okay, was case laws that was enacted in 2009, 2012, and 2013. And they're referring to a case law back from 1968, okay, where the Attorney General made this comment, and through extensive research has come to find out that no Attorney General has ever gone against, rescinded, reversed, or changed what this Attorney General has said. Not a single one. Not a single attorney General has come forward and changed what has been said. So what this Attorney General said, Mr. O'Connell, what he stated in 1968 is standing law to this day in the state of Washington. The courts don't want you to know that all licenses issued by the DOL are in fact for hire license. Every single license, it don't matter whether it's a motorcycle license, a chauffeur's license, a taxi cab license, just a regular car. You go buy a car and you go and you get it registered. All of that. And they tell you that. Actually, in so many words, they tell you that. You know, they don't actually directly come out and tell you that, but in so many words, they do. They kind of take, because the car is registered to a person, and pursuant to that of the commercial code, a person is a corporation. So there's that. So we have to think about that, you know, and we have to keep that in perspective, because the state considers you a business. You're not an individual, you're a business. And that's pretty sad that that's the way the state thinks, but that's exactly how they think. They don't believe that there are citizens. You're businesses. You're walking businesses. You're untapped resources of revenue. Now, granted, that's neither here nor there, because that doesn't ever mean anything, and that's okay. But the bottom line is license and registration, not required. If you're not doing business and you're not under any contract, okay, you don't need a license. Now, if you remember in a previous video I made a video addressing a Title 34 vehicle theft deterrent program, or as the government calls it, the program. That program, pursuant to of Title 34 and the Attorney General, if you read Title 34, the Attorney General says that you can register your motor vehicle voluntarily. Okay. So let's think about that for a minute. The courts already know that you do not have to register your motor vehicle. Okay. They know this. Your automobile, your vessel, your car. They know this. So they came up with Title 34, which, if you remember when I was telling you, you have to take and cross-reference statutes. So one of the statutes that came to mind was Title 34. When I was reading that, and I thought, well, wait a minute. That's one of the means and ways that they're trying to get people to register their automobiles, through Title 34, a theft deterrent system. But after I got to reading it, and even though it is a voluntary system that you volunteer to register your motor vehicle, the theft deterrent device that they speak about is a license plate. So you have to go back and kind of ask yourself one more question. Well, wait a minute. Well, you don't have to actually ask a question. You have to actually give it some thought. Regardless as to whether or not you sign this voluntary consent form to have your automobile included in that of this theft deterrent program, or the program as they call it, your information's on that plate regardless. It's so the to me that would be kind of mute and kind of pointless to have this program if your information is automatically put on that plate in the first place. It does violate the right to privacy, Fourth Amendment, because your information's still on that plate regardless. Police pull up behind you, he already know who you are. So therefore, your right to travel anonymously has been violated. you know, and again, abuse of the police power, because the state has no authority over that or your private affairs, personal private affairs. That's a guaranteed protected right of the Fourth Amendment of the United States Constitution. So how do you go about protecting that right? Stay anonymous. Granted, they might say something. Granted, they might, you might have to go through the process. But the bottom line is, due process is the law. You can't take anything without due process. And in that session, you know, once you establish the fact that they did violate your constitutional rights of privacy, due process has been served. So keep that in mind. But the bottom line is, I just wanted to go on here live just to actually get a feel of what the live thing was about, and to see how this was going to go, because I just wanted to get a feel to know if there would be any more future lives, or will I just be just going ahead and just shooting regular old videos and uploading them to the site. So yeah, but it was actually fun, kind of fun. Had Sarah Garcia on there. That's the wifey, by the way, and she was on there today, and she left several messages, so I got to answer her back. But yes, baby, I love you a lot, and only the truth goes out from this mouth. And I want to make sure that this message that I'm relaying to you, to all of you out there, this is all factual. Yes, I'm going to tell you something. I'm going to be honest with you. I was on a roller coaster ride with it. There was so much stuff. Yeah, one thing would say one thing, then you had other things saying other things, and things of this magnitude. But then once I got actually into it and actually started reading and actually researching and pulling up archive cases, that actually, when you go online and you see all these case sites that they're publishing online, and you're like, wow, this says that and this says that and this comes with that, and then you're like, that's too good to be true, and then you come to find out, oh, it ain't true. You know what I'm saying? And because what you have is, you have people who've taken and altered cases. Now if you're altering a case to the point to where the alteration actually still derives to the same point that the case is trying to project, my opinion is you should put emphasis at it, or italics at it. This way people would know that this is your personal opinion that you inserted into this, that correlates with the actual opinion of the case. By your having not done that, and you're just inserting your own words into the case, you got to understand the courts know. They have these cases on file. They surely these cases come across their desks on a regular basis, so they know the difference between a fictitious case and a real case. If the case has been altered to fit an agenda, they gonna know that. They gonna know that. Well, this isn't what the case says. So it would always be wise to put on there in your writings emphasis or italics at it. you know and this way the difference can be discerned from what your opinion of the outcome means and what the actual opinion means. I discovered that in case Thompson versus Smith, there was a ridiculously outrageous opinion, okay, that had been altered into the case. And even though it derived to the same conclusion as the case, this individual actually went on further. And now that I'm actually thinking about it right now, the actual opinion that individual inserted into the case that was that of his own opinion, I'm not even sure who it was. They never tell you who it was that actually does the alterations of the case. It could have been sovereign nation, it could have been foreign national, it could have been a Moor, it could have been anyone who added their own interpretation into the case. However, what I was getting at is this: the interpretation of the case actually fits what the judicial system and the attorney general says here in this manuscript that they don't want you to know, that license regulations and forced insurance is not necessary. So with that being said, in the Thompson case, it actually says no license needed. But that's where the case stopped at that point. When it was talking about personal private automobiles, it actually does say no license needed or no license required. Yeah, no license required. So, and they went on to say that no government entity has the right to force license, insurance, forced insurance, registration, etc., etc. True. It actually is 100% true. You know, and the thing is like, if I write a brief, you know, or if I ever have to write a brief, I'm writing the judicial opinion that I have right here, where the judicial system admitted that the license is in fact commercial. And I'm going to force the hand of the jurisdiction of the court because the court has no jurisdiction over it. I don't know, but as you can see down there in the middle of the page, there's the Attorney General's deal. Okay, right there. There you go. Look at that. Now, if you look at that, like I said, this is the opinion of the court. Okay, so in light of that, I have nothing but straight power, because of the simple fact is this came out of Washington. I live in Washington. Imagine that. And and again, like I said, I'm going to say this without prejudice, because I want everybody to know that I'm not taking away from anyone who's doing their own thing, because you can go about doing your thing any way you like. You could become a foreign national. You can put all your stuff in a trust and, all this good things. But what you don't realize is, honestly, none of that's necessary. All you have to do is just be an American citizen standing on the Constitution and the laws that are provided, and you can do every single thing that I'm doing without having to do all that. You don't have to be a foreign national to live in the United States of America and be free. You don't have to be a sovereign citizen to live in the United States to be free. You don't have to retitle United States of America Republic. You can. Like I said, I'm not knocking how you go about doing your freedom. How you do your freedom is your thing. Okay. And all the blessings and love, much love to everybody that is successful and is doing their thing. I love you all because we all are out here doing the exact same thing, just in our own different way. Okay. Now, there is some things, like I do actually give a notice of liability. I actually utilize some of those things, some of those forms and things of that magnitude. However, I'm slowly learning and discovering that none of that's actually necessary. Well, I won't say the notice of liability is not necessary because I actually like to have something like that on file and in the file. In the event that I am harassed and bothered, then they know that incoming lawsuit coming, and whatever price is on that notice of liability, that's what they're going to pay per hour. So, and that's actually for the impounding of my automobile, the detainmentship of my person, even the jailing of my person, and that's they're per hour. So my liability notices of liability are per hour, and the first hour is 100,000, 200,000 every hour thereafter. So, these notice of liabilities, I do need to get them out and get them served because of the simple fact is, that's putting them on notice that, hey, you cannot and do not have the authority to take a right and turn it into a crime. And you are not given the authority to take a right and turn it into a privilege. That's putting them on notice, putting them on blast. And the bottom line is I can write a little deal in a travel folder that I would keep in my automobile and actually put this Washington judicial notice right on the very first page to put that officer in even more notice that even the judicial courts confirmed all license are commercial. They admitted it. You can't go against that because the same system that you get a ticket, traffic ticket, traffic is commerce, it's commercial. Traffic is commercial, people. Look it up. Traffic is commercial. Okay? It's fictitious law. It's color, it's color of law. So it's fake law because of the simple fact there's no jurisdiction over it. So you got to keep in mind, jurisdiction is one of the main powers in all of this. It's about jurisdiction. Courts don't have jurisdiction in the matter. The only jurisdiction they have is the regulation of their business. That's it. Your commercial license is their jurisdiction. That's all they have is jurisdiction over the commercial license, and that is coming straight from the courts. Straight from the courts, people. You don't get no better than that. When Cameron Wilson, okay, the gentleman that I featured in a previous video that I did, he showed you what motions he filed in the court once he got his tickets for driving without a license, no registration, etc., proof of insurance, etc., and all those got dismissed. He proved to the whole world in a lower court, yeah, but it's not the point. The point is he proved to the whole world that jurisdiction did not exist. He proved to the world that a title of nobility cannot be is prohibited. He proved to the world that a driver's license is nothing but commercial. He proved to the world that all statutes and policies that are in relation to a driver's license are in fact commercial. Undisputed facts. You can sit there until you're blue in the face and turn into a damn Smurf for all I care. You cannot dispute facts. Of course, you'll have some idiots that will try, but you can't dispute facts. He's put it out there. He's let it be known, and everything that he's done has been verified by this manuscript. You know, but it's not that you would actually utilize other people's work, hard work, and efforts, unless that individual is willing to share that hard work and efforts. The bottom line is you research, do your homework, don't be lazy, don't reap what other people sow, especially if you haven't put in an effort. You know, like I said, when the individual, and thank you, you know who you are, sent me this sent me this manuscript, and the individuals that were involved in the making of this manuscript, I didn't know what was written in the manuscript other than the attached note that came with the manuscript that said what the courts, the state, and the police don't want you to know about the right to travel. So I'm in the know. Officer can sit there and he can commit tyranny all he wants. You might get me right then and there. You might get me right then and there. But that beautiful pension, that retirement, you know, that qualified immunity, all that going out the door, because I own all that. Because one, okay, you're trying to enforce a law that is commercial related only. But you'll have 25-year veterans argue that fact and try to shut you down real quick and tell you, you know, I've been out here 25 years. Yeah, in 25 years, you've been out here enforcing this law and you still ain't got it right. How can you enforce a law you know nothing about when you don't even know the facts of it or the nature of the law that you're trying to enforce, that you've been told to go out and enforce? See, in RCW 46, it specifically states in there at section 2, I believe. Hang on one second. Let me see. Yeah, hang on one second, because I want to make sure that you guys hear this, because this is interesting. And then I'm going to go ahead and get off of here because this has gotten us a little bit too long. So what I'm going to do is I'm going to read this RCW to you real quick. Now, keep in mind, I do have the entire RCW 46 chapter. So in RCW 4620.001, no person may drive a motor vehicle upon a highway in the state without first obtaining a valid driver's license issued to Washington residents under this chapter. The only exceptions to this requirement are those expressly allowed by RC 4620.025. Now, I'm not going to get into that part. The part I'm going to get into is where it says no person may drive a motor vehicle. All commercial words. Supreme Court's validated that, folks. Supreme Court has validated that. Let me show you something here. Let me get you guys on point as to the Supreme Court definitions that were handed down by the Supreme Court. Some of you know it, some of you do not. But it's okay, you know. And then under Title 49, if you really want to get technical, go over to Title 49 under the federal code and look what it says about driver, motor vehicle, etc., etc. Now, keep in mind, all states have to be in conformity with what? Federal Motor Code. What? Yeah, I know. A lot of y'all didn't know that. You're welcome. You can thank me later. So let's go. Here we go. Let's put it right here. Yeah. There we go. Can y'all see that? Can you see that? There you go. What does that say? It says, hang on. There we go. The Supreme Court defines the following terms as follows. Traveler, driver operator. What? Oh, wait. Can you see that? I think it's backwards, but that's page 1. Here's page 2. And see, this is just giving. Oh shit! This is just giving you a little fuel for the fire. There we go. There you go. So there you go. Motor vehicle. What? Oh, 18 U.S. Code 31. What? Oh, man. See, like I said, facts. This comes straight from the United States Supreme Court. Law of the land, people. That's where that came from. The true definitions of what those words mean. Title 49 under the Federal Motor Code actually has them listed the exact same way. For the exception of traveler. They don't have traveler in their code. Okay? But they do have driver and operator, and interestingly enough, in their operator definition says see driver. And driver is an individual who controls and or operates that of a motor vehicle working in that of commercial commerce. Oops. Now, the police could sit there and use those terms all day and night, and actually police have been led to believe that the way they utilize the words mean a different meaning. They don't. The Supreme Court has also made a distinct difference between an automobile and a motor vehicle. The Supreme Court has also made a distinct difference in travel and driving. Now, this is law of the land. So, like I said, if you get a ticket and you can't seem to beat it for lack of jurisdiction in the court, and you go to appeal, you need to look into the definitions that the Supreme Court has handed down and make sure that you insert these into your motions. Hence, I am going to actually do a video on a few motions and a memorandum that you can actually put into court that will win. Cameron Wilson has provided me with links to the motions that he's utilized that won him his cases. Okay. So I will actually be doing a reading of those motions with the granted permission of Mr. Wilson, which he has granted me. So therefore, in that sense, I will be making a video on those motions to take you through step by step as to what the motions are. So anyway, thank everyone who was on here tonight. Sarah Garcia, Mama, I love you. And all my haters, I love you guys too. I love y'all. Y'all make me strong. Y'all can't steal my energy. I got too much. Y'all can't handle the energy. That's why a lot of y'all quit debating. That's why a lot of y'all walked away. Much love for y'all. Because I know I turned y'all. And y'all don't like it. But it's okay. I'm glad to the fact that you don't like it. But I'm also glad to the fact that you've been educated to the facts. And that you've come to the light. So with that being said, much love. Until the next live stream. I don't know when that will be. like I said, I might not. I don't know. But with that being said, this is Dark Angel. I hope that with that judicial reading that I read to you about the judicial system actually admitting that all driver's license issued are in fact for that of business, has set things in a different perspective for you and made you wake up and realize that, what you've been told and what's actually going on, two different things. With that, much love. This is the Dark Angel. Deuces.